you and your whole association!
Mara hired an independent surveyor named Ethan Cole. Ethan was 36, quiet, and precise. Before becoming a licensed surveyor, he had served as a combat engineer. He arrived carrying 2 equipment cases and a rolled copy of my recorded deed. "I do not need to know who is angry with whom," he said. "Just show me the legal description." We began with the metes and bounds description from the corrective deed. Then Ethan compared it with historical county maps, Army Corps shoreline surveys, aerial photographs from the 1960s, modern satellite coordinates, the old recreational agreement, and the duplicate parcel map created for Silver Pines. The maps did not merely differ. The Silver Pines map shifted the island boundary outward in one area and inward in another, almost as if someone had redrawn the shoreline to make the cabin layout fit. "This was not caused by erosion," Ethan said. "How can you tell?" "Because erosion does not produce straight lines. The original survey referenced 4 iron boundary pins driven deep into the granite. If those pins still existed, they would provide physical evidence independent of every disputed document in the county system. We found the first one beneath 6 inches of soil near the northern point. The second stood near the western shoreline beneath the roots of a cedar tree. The third was almost hidden under a layer of gravel spread by the construction crews. The fourth was gone. The hole remained. The surrounding granite showed fresh scraping, and several broken pieces of concrete had been dumped over the location. Ethan crouched beside it. This was removed with equipment. Recently. That missing pin would have marked the southeast boundary closest to the largest cluster of cabins. Removing it did not change the legal boundary, but it proved someone understood exactly where the real line was. Fortunately, I had placed trail cameras around the island years earlier to watch deer and discourage poaching. Most had been removed or destroyed when construction began. One camera near the southeast point had been mounted higher than the others inside the split trunk of an old pine. The crews had missed it. I retrieved the memory card after midnight from a boat without stepping beyond the water line. Back at the house, I opened the files. At 2:13 in the morning, 3 weeks before construction officially began, a pickup truck entered the frame. The logo on the door belonged to Crowley Lake Development. 2 men got out. One held a map. The other carried a hydraulic extraction tool. They worked near the iron pin for almost 40 minutes. At 2:56, the truck left with something long and dark secured in the bed. Mara leaned closer to the computer screen. They removed the marker before the first machines arrived. They knew where the boundary was. The following Monday, I went to the causeway with Ethan and a folder of certified notices. The construction foreman, Cole Barrett, met us near the gate. He was a large man in his late 40s with gray beginning to show in his beard. Unlike the compliance guards, he did not posture or raise his voice. He looked tired. "I have already been told not to speak with you," he said. "I'm not asking you to discuss the title." I held out the envelope. "This is formal notice that ownership is disputed and that the court has warned everyone proceeding at their own risk." Cole looked toward the office trailer. Vanessa was standing outside watching us. "I cannot stop the job because you hand me a letter." "I know." He read the first page. His expression changed when he reached the paragraph describing the alleged forgery. "You're saying the deed was fabricated." "I'm saying a dead woman supposedly notarized my signature." He looked toward Vanessa again. Then he signed the receipt. Later that afternoon, Cole sent a brief text to Ethan. It contained a screenshot from Vanessa, Mercer line. "Ignore. Foundations must be locked before the next hearing." Mara printed it immediately. "That is actual notice," she said. "Not just of the dispute. Of the boundary itself." Construction continued. Within days, concrete foundations spread across the eastern half of the island. Ethan completed the certified survey 2 weeks later. We unrolled the map across my dining room table. My deed boundary appeared in a thick black line. The locations of the 26 cabins were marked in red. I expected some to cross the boundary. Perhaps a porch here. A foundation corner there. Instead, every red structure sat entirely inside the black line. The clubhouse, the utility building, the roads, the septic trenches, the marina foundations, all of it. Ethan pointed to the nearest cabin. This one is 87 feet inside your boundary. Then he moved his finger to the farthest structure. This one is almost 400 feet inside. I stared at the map. There is no overlap dispute. No, he said. There is no reasonable alternate boundary that puts these buildings on Silver Pines property. Across the lake, another roof frame rose above the trees. Vanessa believed she was building a resort faster than I could stop her. What she was really building was a larger damages claim with every truckload of lumber. The certified survey gave us the physical truth. The tax records showed us how someone had tried to bury it. Mara and I returned to the county assessor's office and requested the complete administrative history for both parcel numbers connected to the island, every application, every revision, every internal note, every attached map, every person who had opened or changed the file. The clerk who helped us was named Nora Bennett. She looked to be in her early 30s, with dark hair pulled into a loose knot and the careful manner of someone who had learned not to trust a computer screen simply because it displayed official information. Nora pulled up my original parcel first. It had existed for decades, 11 acres, Black Pine Island, owner Daniel Mercer. The tax history was clean. Then she opened the second parcel. It covered almost the exact same land. The acreage differed by less than 1/10 of an acre. The shoreline matched mine. The access route matched mine. Even the small cabin my father built appeared on both maps. That should have triggered an overlap warning, Nora said. Did it? Mara asked. Nora clicked through several internal tabs. Yes. She turned the monitor toward us. A red alert had appeared when the new parcel was created, potential duplicate legal description. Review required. Below it was a note, override approved. Administrative correction. The approving official was Ray Caldwell. Can one person override that? I asked. Not normally. She opened another screen. For a routine correction, planning could submit supporting documents. But when ownership changes or legal descriptions overlap, the recorder and assessor were both supposed to verify the transfer. Did that happen here? Mara asked. Nora shook her head. The verification boxes were marked complete, but there are no review notes. Who marked them complete? She checked the activity log. Ray Caldwell. The same man had submitted the correction, approved the overlap, and certified that other departments had reviewed it. Mara asked for the original application. Nora retrieved a scanned packet. Trevor Crowley had submitted it 2 years earlier. The legal contact was Miles Denton. Attached to the application were the disputed quitclaim deed, the altered boundary agreement, the Silver Pines development map, a letter signed by Ray Caldwell, and a consent form carrying my signature. I had never seen the consent form before. According to it, I had authorized the county to merge my island into the Silver Pines master parcel. Mara placed the consent form beside the quitclaim deed. Same tilt. Same spacing. Same break in the final stroke. Nora then found something stranger still. The second parcel had been assigned a tax value of only $12,000 during its first year. My original parcel had been assessed at more than $800,000. Why was theirs valued so low? I asked. Nora studied the classification code. It was entered as undeveloped common recreational land. That kept the taxes low, Mara said, and made it look like HOA property. The following year, after construction permits were approved, the classification changed to commercial resort development, but the tax bill was still sent to Crowley Lake Development at the lower interim rate. The county had collected full property taxes from me while charging Vanessa's company a token amount for the same land. Before we left, Nora lowered her voice. There is something else you should know. Who? The user account belongs to Ray Caldwell. What did he change? Nothing that shows in the current version. Mara asked whether Nora would be willing to testify. I would need a subpoena, Nora said. You may get one, Mara replied. We sent the signatures to a forensic document examiner named Dr. Samuel Voss. 3 days later, Mara and I joined him by video call. He displayed the quitclaim deed and the boundary consent on the screen. At first glance, he said, the signatures appeared natural. That was why no one had questioned them. Then he enlarged both examples and placed one over the other. They aligned perfectly. Not nearly. Not approximately. Perfectly. No person signs their name exactly the same way twice, Dr. Voss said. One signature image was digitally duplicated and placed on both documents. He then examined the notary section. The typeface differed slightly from the rest of the document. The spacing was too uniform. The seal had no visible pressure distortion. The notary identification number did not belong to Helen Price. It belonged to another notary in a different county. Finally, he examined the surveyor's seal on the updated plat. The seal belonged to Arthur Bell, a respected surveyor who had worked in Black Pine County for 40 years. Arthur Bell had been dead 3 years before the date printed on the plat. Dead professionals are useful to forgers, Dr. Voss said. They cannot deny signing. The evidence was becoming stronger. But as our case grew, the situation inside Silver Pines began to deteriorate. The first sign was an emergency email sent to every homeowner. Vanessa announced a $4,000 special assessment. A retired accountant named George Miller called me one evening. Daniel, I cannot be seen taking your side, he said, but something is wrong with the numbers. The annual report says we had more than $3 million in reserves. Now they claim the court bond forced an emergency assessment. Both things cannot be true. After that call, Mara received an anonymous message. It contained a photograph of an internal balance sheet. The official HOA report showed more than $3 million in reserves. The internal sheet showed less than $200,000. At the bottom, someone had circled a series of transfers totaling nearly $2.8 million. The recipient was listed as TC Community Consulting. Trevor Crowley's initials. The anonymous sender contacted Mara again the following morning and arranged a meeting at Miller's Diner on Route 16. That night, Mara went inside while I waited across the road at an all-night gas station where I could see the parking lot. 25 minutes later, she called me in. The woman sitting across from her was Emily Park, assistant treasurer and bookkeeper for the HOA. She looked exhausted. If Vanessa finds out I spoke to you, she will destroy my career, Emily said. She already tried to destroy my property, I said. I'm not here to expose you. I'm here to understand what she's doing. Emily opened a thick document envelope. The first document she removed was the complete 1976 recreational agreement. I recognized the first 3 pages immediately. They were the same pages Miles had shown Judge Aldrich. But Emily's copy had a 4th page. That missing page changed everything. The agreement allowed Silver Pines residents to use the causeway and visit the island for 2 community picnics each year, nothing more. It specifically stated that the access was non-commercial, non-transferable, revocable under certain conditions, limited to daylight recreational use, and subject to the Mercer family's continued ownership. No permanent easement was created. No structures could be constructed. No rental activity was permitted. The final paragraph said the agreement would terminate upon my father's death unless renewed in writing by his legal successor. My father had died 11 years earlier. I had never renewed it. Where did the HOA's 3-page version come from? Mara asked. Miles prepared it for the permit package, Emily said. Did he know there was a fourth page? Emily gave a bitter laugh. He told Vanessa the last page created unnecessary ambiguity. Ambiguity? I said. It ends their entire claim. Emily then showed us the reserve statements. The reserve fund had been drained through transfers to companies tied to Trevor Crowley. After the judge ordered the escrow deposit, Vanessa had emptied maintenance accounts, taken a short-term loan secured by future HOA dues, delayed payments to contractors, borrowed from an insurance reserve, and used homeowner dues already allocated for water and road repairs. Why not stop construction? I asked. Emily looked at me as if the answer were obvious. Because the cabins are the only way she can put the money back. She then produced a financing agreement from a private investment firm called Northstar Leisure Capital. Once the cabins were finished, furnished, permitted, and ready for occupancy, Northstar would provide up to $14 million through an acquisition and operating deal. Vanessa planned to use that money to repay the short-term loans, refill the reserve accounts, cover the escrow, pay contractors, hide the earlier transfers, and collect a development fee for herself and Trevor. This agreement requires clean title, Mara said. Emily nodded. And certificates of occupancy and at least 18 signed purchase or long-term rental commitments. But the judge prohibited sales and transfers, I said. They renamed the deposits. Buyers are paying refundable membership reservation fees. 21 families had already paid. Vanessa was not racing against me. She was racing against her own books. Then Emily produced the most important item in the envelope, a photocopy of an old safe deposit account card from Black Pine Community Bank. My father's name was on the front. It was in a title research folder Miles ordered from storage, Emily said. He was searching for the original deed before construction began. Black Pine Community Bank had closed 18 years earlier. Its records had been absorbed by a regional bank in another state. I had assumed the safe deposit box was emptied when my father's estate was settled. At the bottom of the card was a handwritten note, contents transferred to off-site custody. Account holder unlocated. Your father's box may still exist, Emily said. For the first time in weeks, I felt something like momentum shift in my favor. The bank that had inherited the records was 87 miles away. My son Luke drove. I sat beside him with the probate order, my identification, the safe deposit account card, and every document Mara thought the bank might demand. Luke was 31, practical, and usually calm under pressure. For the first 20 miles, he said nothing. Then he glanced at me. You really think Grandpa's deed is still sitting in a box after all these years? I think Miles Denton believed it might be. That's not the same thing. No. We reached the regional bank near noon. A records manager named Patricia Sloan met us in a conference room. She examined the account card and probate documents, then disappeared for nearly 40 minutes. When she returned, she carried an old file folder. The box was transferred to off-site custody after the original branch closed, she said. It was never claimed. Does it still exist? Yes. After another hour of signatures, identity checks, and phone calls, Patricia led us into a secure room. A bank employee placed a long metal box on the table. The label on the front had faded almost completely, Mercer, Thomas E. My father's name. I rested my hand on the lid. For a moment, I thought about him placing that box in the old bank. He had been a careful man. He trusted paper more than promises and steel more than paper. Luke stood beside me. Open it. Inside were several yellowed envelopes, a rolled survey, a small notebook, and a bundle of documents tied with cotton string. The first envelope contained the original 1949 warranty deed. The second held the 1953 corrective deed confirming the causeway and eastern shoreline. Behind those were the recorded survey, the probate order transferring the island from my grandfather to my father, the later order transferring it from my father's estate to me, and the title insurance policy with a continuation endorsement. No land trust. No quitclaim transfer. No Crowley Lake development. No gap in ownership. The chain was complete. Then Mara found something else in the photographs we sent her. The corrective deed contained an old fixture provision. The meaning was simple: any permanent structure placed on the land without the owner's written permission could, subject to court determination, become part of the real property. The cabins were not trailers. They were fixed to concrete foundations, connected to buried utilities, attached to roads, septic systems, and a marina. If the court confirms your title, Mara said over the phone, you may have several remedies. Removal? Yes. Or the value of the land use, environmental damages, punitive damages, and legal fees. Or you could argue that the structures became fixtures attached to your property. Luke leaned closer to hear. You mean the cabins could become mine? I mean the court may give you that option. Across the table lay 70 years of ownership history. Across the lake stood 26 nearly completed cabins. For months, Vanessa had acted as though every wall she raised made her claim stronger. Now every permanent improvement might become another thing she had built for me. By the time we reached Black Pine Lake again, Silver Pines was preparing for its grand opening. Vanessa had ignored the court's prohibition on sales by changing the language. The cabins were not being sold. They were being reserved. Buyers paid refundable membership fees ranging from $25,000 to $60,000. A white tent had been erected near the shoreline. A red ribbon stretched between two decorative posts. North Star Leisure Capital sent 3 representatives. Vanessa stood at a podium in front of the completed cabins and smiled for the cameras. All title issues have been fully resolved, she announced. These cabins are secure, legal, and ready to become the finest private island community in the region. Mara stood beside me with a recorder in her hand. She just lied to buyers on camera, I said. She lied to investors too, Mara replied. That helps. 3 nights later, the temporary water line serving the construction site was cut. A buried electrical cable was damaged near the eastern road. The next morning, Vanessa held a press conference and called it deliberate sabotage. By noon, Miles had filed an emergency petition for an ex parte restraining order. The affidavit claimed I had circled the island repeatedly after dark, threatened that the resort would never open, entered restricted areas, interfered with utilities, and created a danger to workers and future guests. The judge issued a temporary order before Mara could present our response. It prohibited me from coming within 500 feet of the island, contacting Vanessa, the HOA board, or any contractor, accessing trail cameras near the causeway, or interfering with any utility serving the construction site. The order was signed while Luke and I were driving home from the bank. Vanessa knew I did not know that. That evening, a Silver Pine security employee called my cell phone. He said the construction crew had found one of my trail cameras and Vanessa had authorized its return if I collected it before 6. I should have recognized the trap immediately. Instead, I thought about the footage. I took my boat onto the water. From several hundred feet away, I saw a folding table near the shoreline. My camera sat on top of it. 2 sheriff's deputies stood beside the fence. Vanessa was there. So was one of the compliance guards. A tripod camera pointed toward the water. My phone rang. Daniel, where are you? Mara asked. On the lake. How close are you to the island? Maybe 600 feet. Turn around. What happened? Vanessa obtained a temporary restraining order. You cannot come within 500 feet. I immediately reduced the throttle. The boat drifted forward. From shore, Vanessa raised both arms. Daniel. Your camera is right here. One of the deputies watched me through binoculars. The tripod recorded every movement. Vanessa knew I had not been served. She wanted me to cross the invisible line before anyone told me the order existed. Then she could claim I had knowingly violated it. I shut off the engine. For a few seconds, the boat drifted sideways. Vanessa shouted again. I restarted the motor, turned away, and went home. All she got was footage of me leaving. Mara filed an emergency motion to dissolve the restraining order. The hearing was scheduled for the afternoon before trial. Fortunately, Vanessa had built the accusation around a specific time. The water pipe had been cut at approximately 9:20 the previous morning. The electrical fault occurred less than 15 minutes later. At that time, Luke and I were 87 miles away. My truck's navigation history showed our route to the bank. A gas station camera recorded us purchasing coffee at 9:11. The bank's security system logged our entry at 9:34. Patricia Sloan signed an affidavit confirming our appointment. Cole Barrett helped with the rest. Through Ethan, he told us the electrical cable had not been cut from outside the site. The power had been disconnected at a locked distribution panel inside the construction fence. Only supervisory staff had keys. The water line had been cut with a ratcheting pipe shear used by the plumbing subcontractor. The tool had been signed out the night before under the name of Trevor's maintenance supervisor. Then Emily forwarded an internal message Vanessa had sent to Miles, "We need Mercer restricted before trial." Another message from Trevor read, "Utility incident is handled. File first thing." At the emergency hearing, Judge Aldrich looked unimpressed. Mara presented the GPS history, bank video, gas station footage, internal utility logs, contractor tool records, and Vanessa's messages. Then Cole Barrett appeared under subpoena and testified that the damaged cable had been disconnected from inside a locked panel and that Trevor's maintenance team had been on site after midnight. Judge Aldrich dissolved the restraining order. "Protective orders exist to prevent actual harm," he said to Miles. "They are not litigation weapons." The title trial began the next morning. Heavy rain flooded the northern road. A fallen tree closed the direct route from Mara's office to the courthouse. We had secured the original deed in Mara's safe during the restraining order hearing. Now Luke had to drive us around the lake and through 2 neighboring towns. At 8:41, we were still 19 miles away. At 9:07, Luke stopped at the courthouse curb before the truck had fully settled. I grabbed my father's leather briefcase and ran through the rain. By the time I reached the security entrance, my lungs were burning. When I opened the courtroom door, Miles Denton was already standing before Judge Aldrich. Mara sat alone at our table. Every seat behind her was occupied. Silver Pines residents filled 2 rows. Contractors and cabin buyers sat behind them. Reporters lined the back wall. Northstar Leisure Capital had sent 3 attorneys. Emily sat near the aisle with her hands folded tightly in her lap. Cole Barrett was 2 rows behind her. Nora Bennett sat beside a county lawyer. Ray Caldwell stared straight ahead. Trevor leaned close to Vanessa and whispered something. Vanessa turned when she heard the door. For 1 second, the confidence disappeared from her face. Then she saw the briefcase. That was when she understood. The clerk logged the original documents while Miles continued his opening argument. He spoke slowly and confidently. "This case has been presented as a dramatic story of theft, but the legal question is narrower. Which party held the most recent recorded interest when construction began? Crowley Lake Development held a 2019 quitclaim deed, an approved parcel correction, valid construction permits, and a recorded development plan. Mr. Mercer knew construction was underway. He objected, certainly, but after his request for an injunction was denied, he deliberately stood aside while my clients invested millions. He watched 26 cabins rise. He photographed them. He tracked every delivery. He waited until they were finished, furnished, and commercially valuable. Now he claims the structures should belong to him." Mara wrote something on her pad and turned it toward me. Let him finish. When her turn came, she did not begin with the original deed. Vanessa expected that. So did the reporters. Instead, Mara held up the 1976 recreational agreement. Mr. Denton has asked the court to focus on reliance. We agree. She displayed the 3-page version submitted by the HOA. Then she displayed Emily's complete copy. 4 pages. The defendants omitted the final page, Mara said. She read the key provisions aloud: non-commercial use only, no permanent easement, no construction rights, termination upon the death of Thomas Mercer unless renewed by his successor. Daniel Mercer never renewed it. Miles objected. Mara called Emily to the stand. Emily testified that she had found the complete agreement in the HOA's historical files and watched Vanessa scan only the first 3 pages for the permit package. Did Mr. Denton know there was a 4th page? Mara asked. Emily looked toward Miles. Yes. How do you know? He said the final page created unnecessary ambiguity. A quiet reaction moved through the courtroom. Did it create ambiguity? Mara asked. No. What did it create? Emily looked toward me. It ended the HOA's claim. Then Mara played the board recording. Vanessa's voice filled the courtroom. Mercer's deed is probably in the old bank archive. Finish the cabins before he finds it. The room went silent. Mara then called Nora Bennett, who explained the duplicate parcel warning and how Ray Caldwell had overridden it. She testified that my original parcel remained active, taxable, and listed in my name while the false parcel had been created on top of it. When Mara later called Ray Caldwell, he answered only basic questions. Once she asked about his communications with Trevor and Miles, his attorney stood. Mr. Caldwell invokes his right against self-incrimination. That changed the atmosphere in the room. This was no longer a confusing title dispute. A county official was refusing to answer because his answers might expose him to criminal charges. Then Dr. Samuel Voss took the stand. He overlaid the signatures attributed to me on the quitclaim deed and the boundary consent. They matched perfectly. He explained the duplicated signature image, the false metadata, the dead notary, the dead surveyor's seal, and the impossible chain of execution. One anomaly may be an error, he said. A dead notary, a dead surveyor, duplicated signatures, false metadata, and an impossible chain of execution form a pattern. Cole Barrett testified next. He confirmed that he had received written notice before the foundations were completed and identified Vanessa's message, Mercer line. Ignore. Foundations must be locked before the next hearing. What did that mean? Mara asked. That we were to build across the boundary shown on Mercer's survey before the court could stop us. Vanessa whispered angrily to Trevor. Judge Aldridge looked toward them. Miss Crowley, another interruption and I will remove you. Finally, Mara called me. Mr. Mercer, did you sign the 2019 quitclaim deed? No. Did you authorize the creation of the Silver Pines parcel? No. Did you give anyone permission to build 26 cabins on your island? No. Did you attempt to stop construction? Yes. I described calling the sheriff, going to the recorder and assessor, serving certified notices, requesting the injunction, warning contractors, hiring Ethan, documenting the project. What did Judge Aldridge tell the defendants at the emergency hearing? That they were building entirely at their own risk. Why did you not enter the island and physically stop them? Because I was not willing to commit a crime to prevent theirs. Then Mara asked the question Vanessa had feared since the day I walked into court with my father's briefcase. Mr. Mercer, do you have the original ownership records? Yes. I opened the briefcase. First I removed the 1949 warranty deed. Then the 1953 corrective deed. Then the recorded survey, the probate orders, the title insurance policy, the continuation endorsement, the complete chain of title. Judge Aldridge examined the original deed under the courtroom light. The paper was yellowed. The ink had faded. But the county seal remained visible. Miles stood. These documents establish historic ownership. They do not automatically defeat a later recorded transfer. Mara faced him. They do when the later transfer is forged. Miles then turned toward me. Mr. Mercer, you understood that millions of dollars were being invested, correct? Yes. You knew the cabins were increasing in value. Yes. And you allowed construction to continue. No. You stood by and watched. I followed the court's order. You could have done more. I looked at him. I called the sheriff. I went to the recorder. I went to the assessor. I served your clients. I notified the lender. I requested an injunction. I hired a surveyor. I came to court. Then I leaned toward the microphone. What exactly are you suggesting I should have done, Mr. Denton? Driven a bulldozer into their workers? Miles did not answer. I continued. They did not build because I stayed silent. They built after every person involved was warned. I looked at Vanessa. They built because they believed finishing first would make the truth too expensive to matter. Vanessa stood so quickly that her chair struck the wall. He let us finish, she shouted. He knew what he was doing. This was a trap. Judge Aldridge struck the bench with his gavel. Sit down. He wants the cabins, Your Honor. He watched us spend $14 million. Judge Aldridge leaned forward. Mr. Mercer did not give you permission to build. He sought an injunction. He notified your board. He notified your lawyer, your lender, your contractors, and your investors. This court warned you that continued construction was entirely at your own risk. Vanessa slowly sat down. That was not a trap, Miss Crowley, the judge said quietly. Those were exits. You ignored every one of them. No one moved. Finally, Judge Aldridge returned to the bench and delivered the ruling. The court finds that the 2019 quitclaim deed was not executed by Daniel Mercer. The purported boundary consent was created using a duplicated signature. The Silver Pines recreational parcel was formed through an invalid administrative process based upon fraudulent instruments. The court therefore declares the quitclaim deed void from inception, vacates the boundary adjustment, and orders the duplicate parcel removed from the county records. Title to Black Pine Island is vested solely in Daniel Mercer. I closed my eyes for 1 second. Rebecca's dock. Her garden. Her letter. Everything Vanessa had tried to reduce to an administrative inconvenience had finally been acknowledged in a public courtroom. Judge Aldridge continued. All transfers, reservations, occupancy agreements, and financing commitments involving the 26 cabins are immediately frozen. The project accounts are locked. The escrow remains under court control. Miss Crowley, Trevor Crowley, Crowley Lake Development, and Silver Pines HOA are prohibited from entering the island without written authorization. The clerk will send the evidentiary record to the district attorney, the state attorney general, the state bar, the county ethics office, the notary commission, and the licensing board for surveyors. Then he addressed the question everyone had been waiting for. The court has determined who owns the land. We have not yet determined what happens to the 26 structures unlawfully attached to it. The damages hearing took place 3 weeks later. By then, Silver Pines had changed completely. Residents who once repeated Vanessa's claims were demanding audits. Contractors had filed liens. Northstar Leisure Capital had withdrawn from the project and sued Crowley Lake Development for fraud. The 26 cabin buyers wanted their deposits back. Vanessa no longer arrived at court surrounded by supporters. She came through a side entrance with 2 attorneys and said nothing to the cameras. Judge Aldrich began with damages. Mara presented the cost of the destroyed dock, the damage to Rebecca's memorial garden, the removal of trees, the disturbed shoreline, the environmental work required to bring the island back into compliance, the legal fees, survey costs, forensic examinations, title restoration, emergency motions, the staged restraining order, and the false accusations. The total rose quickly. But money was only part of it. Judge Aldrich found the defendants liable for willful trespass, fraudulent conveyance, forgery, slander of title, destruction of property, abuse of process, civil conspiracy, fraudulent misrepresentation, misuse of HOA funds, and submission of false evidence. Then came the question of the cabins. Miles argued that the structures belonged to Crowley Lake Development because the company had paid for them. Mara pointed to the fixture provision in the corrective deed. The cabins were not movable units. They sat on permanent foundations. They were connected to buried utilities, roads, septic systems, and the marina. They had become part of the land. Judge Aldrich gave me 3 options. I could require the defendants to remove all 26 cabins and restore the island. I could ask the court to supervise a sale of the completed project. Or I could accept the cabins as fixtures attached to my property and pursue additional damages separately. He looked at me. Mr. Mercer, this decision is yours. I had thought about it every night since the title ruling. Tearing everything down would have felt satisfying for about 5 minutes. Then I would have been left with years of environmental damage, mountains of debris, and an empty island Rebecca had once imagined helping people. So I stood. I will keep the cabins. A murmur passed through the courtroom. The one thing Vanessa had wanted most was for those structures to force reality to bend around her fraud. Instead, they had become the permanent proof of how wrong she was. The escrow was released for restoration work, legal costs, and partial repayment of cabin deposits. Additional judgments were entered against Crowley Lake Development, Trevor, Vanessa, and the HOA's insurers. The criminal investigations continued separately. Vanessa was later charged with fraud, embezzlement, conspiracy, and submitting false evidence to a court. Trevor's company was placed into receivership. Ray Caldwell accepted a plea agreement and admitted that he had overridden county safeguards in exchange for payments disguised as consulting fees. Miles Denton was suspended from practice while the state bar investigated his role in the forged documents and the missing 4th page. Emily received whistleblower protection. Cole kept his contractor's license and became one of the most important witnesses in the criminal case. The residents removed the entire Silver Pines board. They did not dissolve the HOA completely. The community still needed someone to maintain the roads, water system, and common shoreline. Instead, they rewrote the rules. No president could approve a major project alone. Every large expenditure required a community vote. Reserve accounts had to be independently audited. Board members could not hire companies owned by relatives. Any future property claim required an outside title review. George Miller was elected treasurer. His first public report began with a sentence Vanessa would have hated. Every homeowner has the right to see where every dollar goes. The island took longer to repair. Before anyone could stay in the cabins, I hired independent engineers and environmental specialists. Some of the foundations needed reinforcement. The rushed septic design had to be replaced. The shoreline required stabilization. Several utility trenches had been installed too close to the lake. We rebuilt everything properly. Cole Barrett managed the work. He refused to take the job at first. I helped build this mess, he said. You also helped expose it, I told him. That does not erase what happened. But fixing it is a good place to start. We rebuilt Rebecca's garden near the eastern shore. Purple coneflowers. Black-eyed Susans. Wild lupin. Luke found a stone worker who repaired the broken memorial bench. The crack remained visible, but the inscription could be read again. Rebecca Mercer, a safe harbor in every storm. I kept 12 cabins as ordinary lake rentals. The income paid for insurance, maintenance, staff, and repairs. 10 cabins were reserved for veterans and their families at no cost. 2 were used by counselors who specialized in trauma and family recovery. 1 became a small community building. The final cabin stood near Rebecca's garden. I filled it with photographs, letters, and the story of the promise she had asked me to keep. We called the island Rebecca's Harbor. It opened almost 1 year after the first bulldozer crossed the causeway. There was no ribbon-cutting ceremony, no oversized scissors, no speeches from politicians. The first guests were 4 military families who had not taken a real vacation together in years. I watched their children run down the repaired path toward the lake. One little boy stopped at the new dock and asked his father whether they were allowed to fish there. His father looked at me. I nodded. As long as he puts back anything too small. The boy grinned and ran for a fishing pole. That evening, Luke and I sat at the end of the dock with 2 cups of coffee. Lights glowed in the cabin windows across the island. Families gathered around a fire near the community building. Someone was laughing in Rebecca's garden. Luke looked over at me. Do you ever regret letting them finish? I watched the firelight move across the water. I did not let them build, I said. He waited. I called the sheriff. I went to the recorder. I went to the assessor. I served notices. I hired a surveyor. I asked a judge to stop them. I took a drink of coffee. But after they ignored the deed, the tax records, the certified letters, the escrow bond, and the court's warning, every nail they drove became evidence. Luke smiled. Mom would have enjoyed that. She would have told me I worried too much about perfection. We sat quietly for a while. For months, Vanessa believed finishing the cabins would make her lie too expensive to challenge. She was wrong. Concrete does not create ownership. Money does not create truth. An official-looking paper does not become real simply because enough people are afraid to question it. Vanessa spent $14 million trying to steal my island. In the end, she built the place Rebecca had dreamed about. She just never understood who it was really for.